Good afternoon, everybody. Welcome to Albany Law School. I am Alicia Willett. I am the president and dean here, and we are thrilled to have you all here for what's going to be a really great afternoon. There is no better time and no better place to have this discussion. You just need to look at current events to know the importance of the questions that we're going to address about a free press, First Amendment, the search for truth, fake news, and all of these timely issues. And there's no better place than Albany Law School to host this event because our author and the star of the show, David McCraw, is a graduate of Albany Law School. And we are very happy to have him back to the place where he learned about the First Amendment. So let me introduce our two folks who will be talking, our conversant and our author. I'll give you a little bit about their backgrounds. So first, Rex Smith will be our conversant. He is the editor of the Albany Times-Union, and he's been in that position since 2002. In 1991, he was named the editor of The Record in Troy before joining the Times-Union, where he joined as a managing editor of the News. Prior to moving to Troy, he served as the Albany bureau chief and national correspondent for Newsday, the Long Island newspaper, which he joined as a reporter in 1980. He has a Master of Science from the Columbia University Graduate School of Journalism, a Bachelor of Arts cum laude from Trinity University in San Antonio, Texas. He is a past president of the New York State Associated Press Association. He previously served as a Pulitzer Prize juror, and he is a frequent host on the Media Project, a nationally syndicated weekly program produced by Northeast Public Radio. David McCraw, class of 1992, is the Deputy General Counsel at the New York Times. He's been in that position since 2002, leading the paper's fight for freedom of information, defending it against libel suits, and providing legal counsel to the reporters breaking the biggest story of the year. He's also sued a number of presidents a number of times, both sides of the aisle, so equal opportunity lawyer. He received his JD from Albany Law School, where he was the class valedictorian, and he gave probably the best valedictory speech I've ever heard. He received a master's in communications from Cornell, his bachelor's degree in journalism from the University of Illinois at Urbana. He has been a great friend to the law school. He was our commencement speaker in 2017. He was our alumnus in residence in 2013. He is a member of our board of trustees, and he also does some things at some other lesser law schools. He's been an adjunct professor at New York University Law School and a teacher at Harvard Law School. But we forgive him those transgressions. He's known around the world for his work on the First Amendment, and he conducts workshops and performs pro bono work for freedom of the press. And we are thrilled to welcome him home. Please join me in welcoming Rex and David. Thank you.
Well, this is a great honor. I've known David for quite a while and been in a number of conversations, convocations and the like with him. And it's wonderful to be here with someone who is described by the President of the United States as a great lawyer. That's what...
My bedside manner, right?
That is what he said. He's got a great bedside manner if he were a doctor. So if you were a doctor, you'd be a great lawyer or something like that. But you know, Donald Trump would know because he hired Rudy Giuliani and Michael Cohen. So who knows great lawyers? Anyway, it's really great to be here. So the question of what it is that David does kind of can be described first, perhaps, if you read Preet Bharara's very favorable review in the New York Times book review of this book. And I'll just tell you how, and by the way, you know what a book review editor thinks of your book by who they select to review it. So I think it's a feather in your cap that that Preet offered these words. Says that David faced the challenge of vetting articles for libel, obtaining blockbuster documents through the Freedom of Information Act, greenlighting the publishing of purloined secret information, and standing it up to intimidation from unhappy subjects of stories, including one of whom is the current president. So you say it's a joy to be a newsroom lawyer, and probably a lot of lawyers don't describe their work by the term joy. What is it that you find makes it a joy?
First, for all my classmates who are here who thought you'd never have to hear me again in these plays, I thank you for your sacrifice and your service. Thank you for being here. In one of the first weeks I was at the New York Times, the first call I received in the morning was from somebody wanting to know whether a story was going to violate the German national security laws. And the last call I received that day was from an editor at one of our small papers in Santa Rosa, California, asking what I knew about the municipal regulations of yard sales in Santa Rosa. The common thread there was I had no clue what the answer was. How can you not find joy in that? And yes, I made up answers to both. Yeah.
Absolutely, but they sounded persuasive.
Yeah.
Yeah. So there's range in it, surely.
I use my bedside manner. Just like
It always comes in handy. But, I would say this, by the way, is a wonderfully written book, and I say that directly without adding the phrase for a lawyer's writing. That is not necessary to add because it is really really a joy to read. But I wonder, before you came to Albany Law, you were briefly a reporter, right? And I wonder to what extent you think your current career might have been influenced by that experience.
I received a note today, and I'll get to that, but I received a note today from a lawyer at one of the networks, and I won't mention NBC by name, but a friend of mine at NBC, and who's a lawyer, and she said, this is so well written. It's what I'm on vacation. It's just such a great beach read for me, and I thought to myself, that says a whole lot more about you than it does about me. But if lawyers find this to be a good beach read, I'm all for that. I think the answer to your question, Rex, is that I was the president likes to say the failing New York Times. I think you'd probably say my career as a failing journalist. I think the day I left journalism, no one cried, and that I'm much better capable of doing something good for journalism in my current position. That said, I do have a really good ear for the genre that is journalism. And I think some lawyers struggle because they will give great conceptual advice. There's an implication here that we don't want to have, or this is an opinion, but it may imply facts. And I'm able to translate that into fixes. I'm able to say, maybe we should try language like this. And because I have a good ear, it usually works out. I remember writing I usually don't do this, but I wrote a paragraph, suggested to the reporters. They said, we'd love it, we'll put it in. We then get a complaint from the subject of the story who focuses on that particular paragraph, and it's talking about the motives of the reporters in writing it and so forth. And I'm like,
excellent. It's interesting, and I appreciate it. Somewhere in here you make the point that you view your task when you're doing pre-publication review, for example, or in a number of other elements of your job, as how to enable publication, rather than just finding nits to pick. It is, how can we actually make this happen? I think that's kind of a fundamental part of it.
That's right. I talk in the book about when I first come to the New York Times, and I've been at the Daily News and fought the fights there, and I come to the Times, and I'm invited down to the newsroom by the business editor, Glenn Cramont. And he does this whole incredible wind-up to introduce me about how that he used to work at another newspaper, and that's the legal department was where stories went to die, and that's not the way it is at the New York Times. And I remember thinking to myself, because I was so green, like, wow, is that true, or has he just really co-opted me? Like, am I ever going to, like, how after that am I ever going to say no to a story? But it was in fact part of the ethos of being at the New York Times that our role is to find a way. And the law in this country is so strong in favor of press freedom, you should be able to find that way. Somehow, some way, you should be able to say approximately what we want to say and do that legally. And it's worked out.
Well, you make that point when you describe the relationship that you tend to have with reporters. And I promise we'll get to the broader constitutional issues soon. But first, to lay the groundwork, we have to, I guess that's a term you all use, we have to talk about what you actually do. But you talk about how reporters, you say in the United States where so much is allowed, that reporters often think of legal concerns as passing inconveniences, speed bumps on the road to reporting and photographing. So, sometimes, I see that in my own newsroom when we're putting things before our legal team at Hearst. Let's just get this quickly through rather than, in many places, looking for the legal implications of what you're publishing would be akin to killing the piece.
Right, and one of the things I should say about the book is that the book wasn't written for lawyers, so when lawyer friends get in touch with me and say they like it, that's a big deal for me. It was really an attempt to write a narrative about how the First Amendment works day by day, and I'm hoping that citizens come in reading it, the general audience coming to read it, may not like what the New York Times does, or may not have great affection for much of journalism, but will come away understanding that we're better off having the kind of protection we do to do the kind of things that we need to do. So it's really written as a narrative and a memoir, and it is there is that tension of what reporters think is allowed, which is usually everything, and lawyers, which is a little short of everything. and I use the anecdote in the book to illustrate that when I was at the Daily News, I get this phone call from reporters, and they're saying, we're being held in the Harrison, New York lockup by the local police, and we were just doing journalism, and this is an outrage. And I said, well, what were you doing? Well, we were climbing over a fence to see whether terrorists could poison the New York water system. The idea being if two heavy-smoking, overweight reporters could get over the fence, any buff terrorist could, apparently. And would I please explain to the chief of police about the First Amendment?
The chief was, I'm sure, really happy to
Very
hear from
impressed,
you.
very impressed. We quickly decided to discuss about distributive justice and a lot of other concepts.
Yeah, that's really good. There's a lawyer from the New York Times on the phone. Oh, good. So I'm going to, again, quote from something you wrote here, which gets to our current situation, where we are in this country at this point, which a lot of this book actually leads up to. But early on in the book, you talk about kind of underestimating Donald Trump, as many people did. And then you finally came to realize, you said, that the anti-press fervor that had been stirred up by the Trump campaign was not really about rewriting the laws of libel or letting rich guys with fancy legal briefs win their suits against news organizations. Something deeper and darker was taking shape. So what do you think it is that's deeper and darker?
Yeah, so this book is a testament to misplaced optimism. Throughout the book, I say that everything is going to be okay, and it's never okay, and I own that. I really thought that, I think of campaigns as sort of a unique genre, that people say things during campaigns to win. They're forgotten. I read George Bush's lips and I got more taxes. Okay, that's just how it works, right? And so I thought a lot of the anti-press rhetoric was essentially a soundbite. But what I came to conclude was actually that the laws were unlikely to change. That I felt that the laws that protect freedom of the press are well established, they work, they're strong, and I don't see a real judicial agenda to change those. Conservatives and liberals tend to agree on both the importance of precedents and the importance of free expression. But what I really thought was going on was encapsulated in the drumbeat of fake news, enemy of the people, stain on society, that it was an invitation to delegitimize the press, to discredit the press, And I thought that in some ways, there was a genius to the soundbite of fake news, because it sounds like the pursuit of truth and is actually just the opposite. It is the invitation to label and to dismiss as opposed to think and decide. And while I was writing this book, there was a poll done, it came out last year, 26% of the respondents thought that the president should have the authority to close news organizations that misbehave. You know, whatever you think about news organizations, the founding fathers disagree with you if that's what you believe. That's really not the plan. And I just think it's so important, not that we love the press or love the New York Times or love CBS or CNN or any of the others, but that we understand the value of free press in that constitutional scheme. I was mentioning to some people earlier that yesterday, following the Mueller report, a woman in Boston wrote to me to tell me how much she hated me, which is always a sunny way to open my day. But basically, she said, you know, you wrote in the Boston Globe that a disbelief press is a danger to a free press, and why should we believe you? So we engage in a healthy back and forth where I'm sending her articles, she's sending me articles. I didn't have time to read them, she didn't have time to read them, but we acted like we did. And it was healthy. And ultimately, I did read them. And then, unfortunately, I had to drive up here, and so I didn't have a chance to get the last word, and I apologize to all my professors. You know, I know that you're supposed to get the last word. It's part of being a lawyer. And when I got to the hotel, I opened up my email, and there she was again. And she said, I want to thank you for responding. I want to thank you for responding. I'm just really troubled by the bias against Trump. And I said to her, I have no problem. I have no problem with that because you're doing your homework. You are actually looking stuff up, and you're thinking about what I'm saying, and we're going to disagree. And that's how it should work. What I don't like is the labeling and the dismissing.
Absolutely, and the power of that is significant. And you make that point, actually, in talking about what the battle is. You say it's going to be a fight about the very nature of truth, about who could capture the hearts and minds of the American people, about who got heard and who got believed. And the difficulty is, I wonder how a serious, responsible, even sedate media can possibly compete against a phrase like fake news, or can compete against let's say, a point of view in this war for the hearts and minds of the American people, where one side doesn't have quite as much respect for facts.
Right. And it's going to be hard. I mean, there's no question about it. It's going to be hard, and we could be talking about education, and we could be talking about training citizens, but this is going to be a process. Absent something huge happening, which I don't foresee, it's going to be people standing up and speaking up. One of the things that in my job that I've developed is a really, really good nut job radar, so that I can look at an email and I know when it's a nut job. And so but my radar failed me the other day, because I was looking at an email, and I thought, oh, here it comes, nut job radar, goes off, because it starts out with, why did you write this book? And I thought, well, okay, I'll read that in the morning. So I read it in the morning, and it's like a really sensible point of view. And that is, she says, why did you write this book? You should be writing for young adults. And that's really a smart point. Not me, I shouldn't be writing for anybody, I should be a lawyer. But but it's a really smart point, is that focus should really be on young adults. And I'm dodging the question a little bit, because I don't think there's a simple solution, but I do think that it's people speaking up. It's people who are not, partisans on the left and partisans on the right. It's the people in the middle who need to say, look, I'm not in this fight, but I do care about that the press be allowed to function. We need that. How hard this is, the last chapter of the book, which is really an essay, is called "The First Amendment is Dead: A Love Story." I actually wanted to use that as the title of the book because I really liked it, and my publisher thought that that was a really nice title, but thought maybe we should try to sell a book, and it would be and that it would be impossible to sell that. I thought maybe in the romance category that it kind of worked, but no. So we went on to other titles.
Right, and work the word times in too, so that you could have a cool cover.
Yeah, well, that was there was much discussion of that. I mean, the part of it is that the drop head is almost impossible to read without perfect inflection unless you're a radio broadcaster by profession, and the heart of this, even though it has truth in the title, it's really about the search for the truth. It's not about giving truth. It's about the habits of the mind and the way news organizations work to get there, to get their best sense of what the truth is, but it's a process. And one of the greatest compliments I had about the book was that somebody from the Washington Post, which I understand is another newspaper, said to me that the one thing it does is that it shows that this is not a matter of fake news. This news stuff is a lot of hard work, a lot of time, a lot of deep dive, and that it really exposes how hard our reporters work to cover North Korea, to cover cyber warfare, to cover Harvey Weinstein, and all the rest.
You know, you write about it in that regard, and it's a column I remember from last year, a Jim Rutenberg column, in which he writes about the testing the norms of objectivity in journalism, which is what's happening now. And says that journalists can't be objective if they have evidence that a politician is a danger to the republic. That's a very dangerous place for it's an opinion column, of course, but he says you have to speak because to do anything less would be untenable. So it puts. Have you ever felt a compulsion to to do more editing than lawyering? To kind of hold on to hold reporters back from putting that kind of analytical words into the paper?
Let me take this in steps. That it's obviously Jim gets a lot of criticism for this. People disagreeing with him. Of course, as you know from the book, it's actually worse than that because he happens to be a defendant in a libel case at the time he's writing it, and now we have just given the opening paragraph to the brief from the other side, okay? We just quote him and say, here you go. That part of Jim's column I do disagree with in the sense that if people are talking about what I think used to be blind objectivity or blind allegiance to form, where person A says the earth is flat, and you get person B says no, it's round, and you say, oh dear reader, you go figure it out. Maybe you can circumnavigate if it's round the earth and find out one way or the other. Those were an unfortunate distortion of what we're trying to get at. I do think we have to put facts in context. I think if someone is saying something that's untrue, we need to point that out. My concern is when that lapses into partisanship, because I think that American journalism over the last 120 years roughly has been practiced on the idea that is not a political, that given newspapers, news organizations are not the organs of established political parties, that we should attempt to be an honest broker of information. And that's where I want to go, but that requires context. It doesn't require he said, she said, you decide allegiance. And ultimately, I think that's where Jim comes out in the column.
You know, I'm just interested in your take on this. This is not actually in your
So
book.
you're asking me whether I edit? No, I don't try that.
You try not to.
Right.
When I was young and living in the Midwest, I was the editor of a little newspaper in Indiana called The Republican. It had been founded in 1856, when newspapers were much more partisan. And eventually, the publisher of The Republican bought out the publisher of The Democrat, which was across the alley. So newspapers have established in America this tradition of not being partisan anymore over the last half century. I wonder if you could just take a look in your crystal ball and you look at what has happened in cable news, at least, where we see the mixing of opinion and straightforward reporting much more dramatically than we do in print. But it is also happening that we put a lot more analysis next to straightforward news reporting and a lot more analytical reporting right into our stories. What's going to come of this? Are we going to go back, do you think, to a more overtly partisan media?
I think you have to look at it broadly, I think of the cable news networks with their point of view and their very provocative programming as part of a buffet. And I think for most people it's dessert. And if the only place you're eating is at the dessert table, you're going to have some really serious health consequences in the end, okay? I think they have a role, but I do think that someplace in that buffet should be what used to be sort of the basic food groups and where people get their sustenance. And that's where I would hope that the mainstream media ends up.
Well, that's a terrific metaphor. Sorry, I'm just doing my editorial analysis here. Well, let's talk a little bit about the actual work that you do and how you interact, because I think it's kind of instructive for lawyers to think about this kind of work. It is interesting, for example, when you're reviewing a story, pre-publication review, you sometimes may have a very important story based on significant use of unnamed sources, and you may not know who the confidential source is. Why is that?
Yeah, this comes up, and I tell the story in the book of Anonymous, which some of you will remember, that a senior official in the Trump administration sends in an op-ed saying that he or she is part of the resistance and talks about what's going on inside. And I use that particular event to talk about my own view of this, and there are a lot of media lawyers who disagree, and that is that I went out of my way not to find out who that individual was. I want to know, for libel purposes many times, where the person is in the hierarchy and how the person knows, the person's still in, still out, whatever it might be. But beyond that, I don't like knowing the name, in part because if I'm a confidential source for another news organization, say the Washington Post, which I was once, but I'm outing myself. I would like to have some assurance that my name isn't being talked about willy-nilly, because it's just one more chance that we can make a mistake. So with Anonymous, Jim Dow, the op-ed editor, called me, said the publisher had said he should talk to me. What did I think? I said, it's going to be fine. And so the op-ed comes out. The response is overwhelming. The number of people who read that, just incredible. And so what happened next is even more incredible, and that is the president said that he wanted the Department of Justice to investigate this person, which really was one of the bearings of the truth about most leak investigations. Most leak investigations are not about national security. They're about trying to silence or intimidate the next person. And I thought it was an outrageous thing to think that this was going to be part of a Justice Department investigation. However, I've heard it, I've seen it, and we need to preserve the documents. And so Jim comes up to legal, and we sit in a conference room, and he has this envelope, which he holds up, and he says, here are my work papers from Anonymous. And he says, would you like to look at them? Totally unfair question. Of course I want to look at them. I want to go to cocktail parties and say, oh, I can't tell you, who it is. I know, but I can't tell you. That is what I want in life, okay? But I said no, and then in this really painful moment, I can still see Jim there, licking that envelope and sealing it, and then handing it to me sealed so I could keep it. And I held it up to the light. I'm not ashamed of that. I didn't get any place. But here's the thing about anonymous sources, Rex, is that concerns me, is that I was at a college media conference a couple weeks ago, and somebody stood up who was a college media advisor and faculty member at a college, and he said, I teach journalism, and I really love the press and all that, and I believe in press freedom, but this anonymous source thing, it really bothers me. Like, how do I know it wasn't the janitor? I'm here to tell you, it was never the janitor. Okay? It's never been the janitor. Okay, you know, that's that, and that idea that somehow that's what's going on is disturbing, especially when it comes from a faculty member who teaches journalism. Should there be fewer anonymous sources? Absolutely, absolutely. We want to be transparent. We want to help people understand. Can there always be? No. There are some realities of the world that people have to be anonymous, but we're really committed to trying to be more transparent about how we do or what we do.
Well, the Times actually changed the standards of American journalism when, a few years ago, you began to more precisely describe the reasons why a source remained anonymous, right? Which gets a little convoluted sometimes, but still, it is, I think, an effort to try to explain to people why you're withholding a name at least.
Yeah, I think that's right, and part of the embrace of my book by the Times, I think, is part of a larger commitment by us as an organization to try to shed light on how we do what we do. That I think there was a time, and you'll remember this, where you sort of had this sense that it was like the jury box. You don't get to, the jury room, you don't get to know how we do this. You should be satisfied with what comes out the other end. If you're not, you can buy the other newspaper, even though there's no other newspaper in most cities. And that you know, this mystery of how it gets done is key. And we're now trying to open that up. There's a 5-part documentary on Showtime, The Fourth Estate, which goes inside the newsroom. I think my book does that as well. We're just trying to be we have a reader center. We're trying to be much more transparent about how we do things. And of course, that was good news for me because the biggest goal I had, the book came out on March 12th, was I wanted to be able to go to work on March 13th. Okay? I did not want to be fired, so yeah.
By the way, does the Reader Center ever have to come to you to say, how much can we put out here? Do you review their work?
I mean, the Reader Center is designed so the readers can come in with questions, and they interview reporters. They have reporters write about how I got the story and all that kind of thing, and I think that's healthy. Yes, they do come to me, and yes, we have been sued over it, where how someone got the story became how I got the New York Times sued for libel, which was really not a great sequel to how I got the story.
That's not so good. So you refer to unnamed sources. Oftentimes, this is a result of leaks. And you had a really remarkable passage in your book, I think, about leaks, where you wrote that a government needs to be able to keep some secrets. Real national security requires it. But leaks are a powerful source for truth. If you are a lawyer in leak world, you inevitably find yourself advocating for something that could best be described as a modicum of unlawfulness, which is not a concept they teach in law school. So what do you mean by that?
I probably should have said a modicum of lawfulness. So, if you think about it, it's both. Right? Yeah. So the truth is that when somebody leaks something, almost inevitably that person is violating the law, whether that is in some fashion. It may be that they're breaching a fiduciary duty to an employer, or in many of the cases, it's a national security secret and it's classified. And that's an uncomfortable position because we as lawyers are raised to be, we're taught to be rule followers. We may do everything possible to spin the rule. We may turn a blind eye to how that rule has been interpreted. But in the end, we believe in the rule of law. And this becomes hard to lawyer it. But I make my peace with that in part by, first, that we have done everything possible to know that it's true, that it's in the public interest, and that all things considered, we're better off knowing it than not knowing it. The government makes it somewhat easier because there is so much classified. And if you go back and read Justice Stewart's concurrence in the Pentagon Papers, it's kind of a brilliant analysis of where we are. And he says famously, where everything is classified, nothing is classified. And that if you over-classified, it just encourages cynicism and carelessness. And that is the world we live in, that so much is classified. The President Obama famously said, there's classified and there's classified. That is now a line that has been quoted in virtually every brief I write, okay, about this topic when I'm trying to get the government to unclassify something. And it would be nice if President Obama had said, oh yeah, when it's bold-faced classified, yeah, that's the real stuff. Don't publish that. But this other classified, that's cool. You can publish that, which is really what he was getting at. And it's so that in many cases the fact it's classified doesn't really tell us much about whether in fact it needs to be secret. We take this very seriously. As I talk in the book, there's high-level discussions about this. The government doesn't have a veto, but our editors do want to hear what the government has to say, make the case, why you shouldn't publish it. And there have been instances where we felt on balance it was right. We have felt in many, many cases, most cases I would say, that publishing was not really going to harm national security and that we should be able to do that. One of the cases that I currently have in front of the Second Circuit is something I never thought I would ever have in a case about national security secrecy and classified information. And that raises a novel, I'm going to put it out there, this is a novel question of law. I know you professors always say that. It's not, but this is really it. And lawyers always say it. It's not, this is it. Can the president declassify by tweet? No one has ever, there's no law on that, right? Well, we have, the president tweeted out about a top secret program, the arming of Syrian rebels. And we took the position that declassified the program, and we filed a FOIA suit asking the CIA to give us all the documents concerning the now declassified program. Safe to say the government takes the position that there is no such thing as declassification by tweet. And in fairness, they won at the district court. We'll see what the Second Circuit says.
Terrific. Well, Twitter, you actually have some interesting thoughts about in this book, and you say that Twitter needs to be fixed, but not by law. What's your point there?
Yeah, the platforms obviously have enormous influence on public opinion, and they're private entities, and they have First Amendment rights. And so you balance those two things, which is, that have they become so powerful that they are a force for something other than good, but at the same time, they are protected by the First Amendment. I'm very concerned about taking steps against the platform as a legal matter that would, in fact, set bad precedent for the First Amendment. I think we need to fix the problems some other way. It's been fascinating to see, well, a couple points about that. One is, I think news organizations have to investigate Twitter and Facebook just the way they do the government. They are so powerful, and we need to report on them. The other day, I made the point that they're like Standard Oil was the turn of the at the end of the 19th, turn of the 20th century. They have just incredible power.
And they do not respond to FOIA requests.
And they do not respond. It's impenetrable. But I do find it interesting that if you follow the arc, especially of Facebook, that right after the election, there was all this concern about whether Facebook had changed, altered, unduly influenced the election, and Mark Zuckerberg said, Trump thinks we're against him. The Democrats think we cost them the election. We must be doing something right. Everybody hates us. Sometimes when everybody hates you, it's because you deserve to be hated. Okay, I don't know if you have experience with that, but that's my experience. But they acted. But Facebook's initial response was, well, it reminded me of when my son was a teenager, and he'd bring the car home with a dent, and you'd ask him about it, and it's like, I don't know, how'd that happen? I didn't see anything, And then you find out that there are, 136 million users of Facebook were reached by the Russians. Mm-hmm. And suddenly, and then you see what happened with Cambridge Analytica, what's happening with our private data. And you now see them attempting to self-correct. And I think those efforts are worthwhile, although, again, there's a lot of power
It's interesting, your first response there to how to fix this was you were putting your faith in journalists. You were saying journalism ought to look into these platforms the same way they do journalism, the same way they do government. That's interesting. So I got to go through a couple of really great cases that you deal with. One that I will always think of is the Mr. Nutterbutter case. Though this had to do with Bob Murray, the coal magnate, where you declined, if I'm remembering this right, you declined to accept an amicus brief from the ACLU.
The ACLU of West Virginia, yeah.
Which, as you write about it, went on to lay out a fundamental principle of American libel law. You can't sue people for being mean to you, Bob.
Yeah.
A great principle.
Yeah, so what had happened was that the New York Times had written an editorial about the influence of various high-end donors to the inauguration, their influence on regulations and changing regulations, one of whom was Bob Murray, who is a coal magnate and a big donor to the Trump inauguration, and also a person who was cheering on the change in regulations about coal mining at the EPA. And we wrote an editorial which he took offense with, and he sued us over. John Oliver, the comedian, then picked up that theme and had this whole scene about how it was rumored that Bob Murray had got into coal mining because a squirrel had advised him to do so. That's not the libelous part. He doesn't challenge that, okay? That's true. But so then John Oliver has this giant character who comes in dressed as Mr. Nutterbutter, and they sort of taunt Bob Murray on the air. And so he ends up suing John Oliver too. And West Virginia ACLU write this incredibly funny brief. It's just hysterical, and it's so good. And it's right on the law. I mean, it says, you know, you can't sue, Bob, you can't sue people for making fun of you. That's how the law works, right? And so he sues them too. And again, as I, you know, this book is a testament to my misplaced judgment. My West Virginia lawyers, who are just incredible. I mean, they're true West Virginia lawyers and very feisty. And they call me and say the ACLU wants to join our case. And then they send me the brief, and they said, don't say yes or no until you read it, okay? Because, you know, I know usually you just say, oh, we love the sport, thank you, ACLU, but read the thing. And so I read it, and it's hysterical, and it's funny, and it's in Bob Murray's face and all that kind of stuff. And I say no. I just felt like I didn't want to. They were going to file it in the John Oliver case because it dealt mostly with what John Oliver said on the air. I just felt that we wanted to sort of separate ourselves from that. We did a serious editorial. We weren't a humor show. We weren't in this with HBO. You know, there should be a separation. And of course, as fate would have it, HBO wins and we lose at the district court. I don't know if the brief would have made much of a difference, but
well, it could have been the edge, you know. This could be what.
Well, this is it. This could be the one. Yeah.
Amazing. So I can see why you're getting joy out of your job. Speaking of which, you got some instruction as well from lawyers for tabloid news sites. So you remember the Gawker case involving the professional wrestler Hulk Hogan. And there was some notion that Gawker got into trouble because, according to these lawyers, quote, Gawker didn't know how to do sex tapes to avoid a defamation claim. So I can appreciate that a lawyer from the New York Times might not know much about how to
We don't do a lot of sex tapes.
Right.
So, yeah.
So what is the legal
Yeah,
principle
so
there?
there's actually a legal principle here. So what had happened was that as most of you will recall, is that Hulk Hogan sues Gawker because they have run excerpts of a sex tape of Hulk Hogan having sexual relations with his then best friend's wife. And Gawker runs it in a very snarky fashion. Many bad things happen in that case. Gawker is financed by, Hulk Hogan's case is financed by a Silicon Valley billionaire who hates Gawker. And ultimately, Hulk Hogan wins that case. for invasion of privacy, not for libel, but for invasion of privacy, and Gawker is forced out of business. But one night at a bar meeting, I got into a very polite civil debate with the lawyer for Gawker about whether it was a big deal or not. And I felt that it was unfortunate, the financing was unfortunate, the result was unfortunate, but it wasn't really a death knell for the press, that we weren't going to get a whole bunch of privacy cases. We weren't going to suddenly be overwhelmed by these cases. And she disagreed, and we had a very good discussion of it. But as I was leaving, the lawyers for some of the tabloids came up to me and kind of whispered to me, like, Gawker didn't know how to do sex tapes. And so, you know, like they were both wearing trench coats. No. Anyway, and so I said, well, how do you do sex tapes? So there's only one thing you need to understand about the law of privacy, and that is that if something is newsworthy, publisher wins. Okay, it can violate somebody. It can be very, very intimate. It could intrude on somebody's privacy. But if you can show newsworthiness, public interest, you win. That's how the law works in Florida and elsewhere, where Florida is where the case was brought. And so they said, well, so you can't just show the tape. You can't just show the tape. What you do is you write a story first saying that Mr. Big Shot, who's married, is having an affair with Mrs. Celebrity, who's married. And then they deny it. Now you have the public interest. You have to show the proof. You have to show the sex tape. Now the public interest is there. And so that's how the tabloids would do it. If you ever get into that situation, don't deny the first story. Just let it go.
Or if you ever become counsel for a tabloid.
Right, exactly right. Yeah.
You were counsel for a tabloid, a respectable tabloid, the New York Daily News.
Yeah. That's not a laugh line. Come on.
No, I didn't say New York Post. It was, and during that, did you find, by the way, when you came to the Times, that you were applying different standards than you had used then?
It wasn't really different standards, but certainly we had a different attitude about it. The joke I always made about the difference between the New York Times and the New York Daily News was that at the Daily News, it took me 5 minutes to read the story, and then there'd be a 20-minute argument. And at the Times, it'd be 20 minutes to read the story, and there'd be a 5-minute argument. But you know, one of the things you had to understand was that many times what a lawyer in my position is doing is simply saying, can you put in a paragraph that says that no one's been charged with a crime? Or can you put in a paragraph that explains what a grand jury is? You know, just give some context. At the Times, with our 40,000-word stories, okay, you want another paragraph? You want another 2 paragraphs? All yours. The Daily News, if it's an 8-paragraph story, you've just taken a quarter or, you know, or an eighth of the story out by adding something. And so you had that. The thing that was lovely about working at the Daily News is a great education was that it was so feisty and so in the face of the establishment. I felt very comfortable with that. And people worked really hard. And I had a friend who was a great reporter at the Daily News, and she would call me at the Times, and I'm going to eliminate the obscenity from this, but all of you will know where to put it. And that when she called, she would always greet me with, "Is the FedEx truck outside?" Because the people came to give their stories to the New York Times. Everybody wanted to be in the New York Times. The Daily News, you had to go out and actually get the damn story.
Yeah,
You know?
Yeah. I'm familiar with the phenomenon. You know, one of the interesting things is in your role as a plaintiff, as a plaintiff's lawyer, the New York Times is still very aggressive in doing Freedom of Information Act litigation. And a lot of publishers aren't doing that so much.
Yeah.
What's the difference?
Well, part of it is that we have a crazy legal department who doesn't know any better, and so we do this. I mean, let's face it, FOIA is broken. You know, the Freedom of Information Act is broken. It doesn't do what it needs to do. It doesn't really lead to as much transparency as there should be. But we feel it's really important as an organization to sue often, so we do that. Because A, sometimes it leads to documents, almost always it leads to some documents, not always the documents we want, but some documents. B, it puts the government on notice that if you tell us no, we're not just going to walk away and say, oh, that's too bad, that we will sue you. C, we think we have a chance to try to create laws that will be more effective. So we keep after it, we keep at it. And the great thing is that when we prevail, we are entitled to fees. And the super great thing is that even though I'm an in-house lawyer, so I don't have an hourly rate, okay, the law, this is a great thing, the law allows me to pretend I'm an outside lawyer and charge the government what an outside lawyer would charge. And I want to tell you, I tell the government I am one great big partner lawyer. Okay? I know all the rates because I pay them. So that's me. I'm worth that much. And so we've actually we pursued the government for a really long time and won at the Second Circuit over the legal memo that justified the drone strikes on people outside the field of battle, and we got a $100,000 check. A $100,000 check keeps us going for a really long time. One of the things I'd mention here, which I think is, it captures some of the flavor both of how I do my job and how FOIA works, is that when we sue the government, an assistant U.S. attorney in AUSA from the Southern District is on the other side. So over time, I'm seeing the same faces over and over again. We have great relationships. They're very professional. They're great lawyers. They are honest. It's always surprising when I do another kind of case and somebody lies to me, and I go, they lied to me, a lawyer lied to me, and then people are going, well, don't you practice law? That happens. I don't go, but the AUSAs are really doing the best they can and are good. But anyway, we'd filed a very complicated FOIA case about government documents dealing with surveillance and about the legal oversight of surveillance by the government. And they email you the documents. And so they email me the documents. And I do, as I always do, I immediately give them to the reporter. I immediately email them to the reporters because I don't know if the government is also giving these documents to others, and I don't want us to get scooped. So boom, comes to me, boom, those documents go. And there are hundreds of pages of documents in this particular release. And the reporter calls me and says, did you see that they have a classified document in there? Now, I don't really want to know that. It's fine, but the government had inadvertently turned over a document that was classified, and so my day gets very interesting the next day because the government wants it back, and I won't give it back, and I keep saying, let's go to the judge. Let's go to the judge, and the guy keeps saying, I'm not authorized. Just give it back. Not give it back, and so he says, well, and I thought this was low. He says, when this happened to the ACLU, they gave it back. Like my patriotism, ACLU up here, New York Times here, that's not really where I want to be in society, okay? So I said, well, I find that hard to believe. So as soon as we hung up, I called my friends at the ACLU, good allies, good lawyers. And there's kind of the hemada. Yeah, well, we did give it back. It wasn't really important. We argued with the judge. The judge told us to give it back. We gave it back. And so I just kept holding my ground on this. And in the end, we published a story based on the classified document. We still have the classified document. The government never did anything. And I can explain a little bit about why that is. But in that chapter where I just tell that story, I refer to the government lawyer, to the AUSAs. I said, I felt bad for them because I knew somebody was in deep trouble in the government. They just turned over a classified document to the New York Times. The New York Times is going to put it in the newspaper. And I said that I felt bad for the two attorneys for the government because they were good guys and good lawyers. The other day at a book signing, the AUSA, who's now out of government, showed up. And he said, would you sign my book? I said, of course. And he said, here's what you should say. Because it's for my mother, it says, to the mom of a good guy and a good lawyer.
Oh, excellent.
Yeah.
Oh, that's a great thing. On the other hand, I don't know if you can do this in a shortened form at all, but because shortly we'll take some of your questions from the floor also. But you had a situation that you described as illuminating, quote, the moral ambiguities of practicing law. In which you believe that the Times was, in effect, kind of double-crossed by Boy Schiller.
Oh, you want to go there?
What do you think about that?
Yeah, I'll try to do this in short because you're right, it's complicated. The New York Times had had a relationship with the Boies Schiller firm for quite a while. We'd have them do business matters from time to time. And as it turned out, a couple years ago, we had a very difficult libel case. And there was a young attorney at Boies Schiller who was the perfect person for this case. So I'd hired him. And he did a tremendous job. Pete Skinner, wonderful lawyer, did a great job, wins the case ultimately. But while we're doing that case, we're at the very tail end of that case, the Harvey Weinstein story breaks. And we're covering Harvey Weinstein. And David Boies represents Harvey Weinstein in a fashion. And that was fine. We knew that. We'd signed a waiver. There was no legal problem with this. He was completely within the rules to represent Harvey Weinstein. But I'm sitting in my office one evening, late in the afternoon, early in the evening, and I get a call from a reporter from a Hollywood reporter, saying, would you like to comment on David Boies hiring private investigators to investigate your reporters? And my answer to that reporter is no, I would not like to comment on that because I've never heard of that. And boy, that sounds not good. In fact, that sounds very not good. And so as it turned out, the New Yorker had just written a story about how Harvey Weinstein had this army of private eyes. And as it turned out, one particular organization, Black Cube, had been hired by David Boies to work for Harvey Weinstein and to investigate our reporters and their sources. And it's a really slimy organization. That's an opinion under libel law. It's a very slimy organization. It's protected, I can say that. The contract, because the New Yorker had it and published it, showed that not only were they being paid to investigate, but they were going to be paid $300,000 if they killed the story. And I just felt that was above and beyond, that whatever the ethics rules say about lawyers with waivers of conflict and so forth, that for the Boies Schiller firm to go after our core business was outside the boundaries of right or wrong. Put aside legal ethics, it just was wrong. So I was directed to terminate them.
I just think that's fascinating. So that was good and cogent and short. Thank you.
I don't always do that, but I do it in the book. So read the book. Yeah.
In the book. So a lot of people will remember that letter, and that letter is it sort of gave David McCraw more, let's say, fame around the country than you might have had otherwise. And that letter being a particular response after a threatening letter from the private lawyers. Was it from Michael Cohen? Or was it?
It was not from Michael Cohen, no.
Anyway, from one of Mr. Trump's private lawyers demanding that you remove coverage from your website. And this was coverage about Mr. Trump's relationships with women other than his wives. And it said...
You know your libel law, Rex. Good job.
And the response that David wrote was just so remarkable that it just drew cheers around the place because in one point he wrote the allegation by Mr. Trump's lawyers was that it had demeaned the president's reputation. And of course, the response was, quote, nothing in our article has had the slightest effect on the reputation that Mr. Trump, through his own words and actions, has already created for himself. So I have to ask you, before we turn to questions from the audience, it seems to me, if I'm reading this correctly, you didn't give an awful lot of thought to that kind of response, which was sort of, you must have had a good time. But were you a little concerned about writing so cleverly in response to a serious legal challenge? Or was it not such a serious
Okay, we've been debating what my state of mind was at the time, whether it was serious. No, really, there's a Jodi Kantor and Megan Twohey, two great reporters, who are writing a book about Harvey Weinstein. And Megan was one of the reporters on that other story, and so we're now debating whether I was worried or not. I thought that I could envision that shortly after Hillary Clinton was elected president, that Donald Trump, with nothing better to do, would sue over it. I mean, I could see that scenario. And so I had to take it somewhat seriously. But they had posted their letter publicly. I felt I had to put up a public response. That paragraph, which is really libel 101, I mean, it's really saying the essence of a libel claim is the diminution of a reputation, and so you start with what somebody's reputation is for that particular characteristic. I felt that that's what I would put in any lawyer letter, was talking about what my case was. Somebody's threatening to sue me. Well, if you want to sue me, you should take into account how weak your case is on this point. And I really thought that the last line was going to be the provocative one, which, as some of you will remember, said that, words to the effect of that if Mr. Trump believes we can't publish this, we would welcome the opportunity to have a court set him straight. That was the final line of the thing, which seemed like more, I mean, like we don't really invite people to sue us that much. It's not really good. And as I say in the book, so I wrote that in about 45 minutes, and then a group of lawyers sat down with me, my good colleagues from in-house at the New York Times, and we went around, well, what about this paragraph? What about that? What, can we change this and change that? And we decided that we should just go with it, and so we send the letter. The PR people have asked for it. They put it up on the web. And suddenly, like, my email just erupts. People start getting, the phone starts ringing, and people start, and so I knew that it was up. There was this very funny thing because a friend called and said, do you realize that your employer just put your phone number, email address, and street address online? Because it was at the top of the letter, and I'm going like, I can't talk right now. I got to answer the phone. And but shortly after the letter goes out, I was in my office, and in those days I had a glass office, and I found out one of the real disadvantages of having a glass office is that you can see the CEO of your company coming to your office well before he gets there, and you can see that he's got the letter in one hand, and he's got this look on his face, and you're going like, maybe that wasn't smart not to check with senior management. Like we are taking on somebody who could be the next president of the United States, and maybe the company would have an interest in knowing what smart-ass thing you were going to say to him. And so Mark Thompson, who's an Englishman, our CEO, comes in and leans against the wall, and he's got the letter, and he says, "This is brilliant."
Yes.
But I will never understand why you Americans capitalize after a colon. I'm here to tell you today I have never capitalized after a colon since that moment, because that could have gone much worse.
Wow, what does he think about the Oxford comma? Can I have the microphone? We'll just run around a little bit. Who has a question here?
And Rex, I'm going to ask,
Should I turn this on?
we are a law school, if we have students who have questions, I'd love to have student questions first.
Good thought. Any students who want to go like this, and I will come running up the steps, do my Phil Donahue imitation. Yes, okay. Here we go. Well, they're too young to remember who I'm talking about, of course. Okay, here I come, running up the steps. This is me running. Okay, why don't you come over to this side, and we'll kind of get here. Here I am. Okay, so tell me, I'll hold on to the microphone.
Is WikiLeaks a journalistic organization in the 21st century, and is Julian Assange a publisher?
I think we're out of time, and thank you all for being here. The answer to that depends on the vintage. If what Julian Assange is being accused of deals with 2010, when the Manning documents were leaked, which dealt with Afghanistan, Iraq, war in both of those places, and diplomatic relations, diplomatic cables from inside the State Department, I think that we have to accept the fact that what he did was an act of journalism, and his website was an act of journalism. I do not know enough about the facts of what happened with the Democratic National Committee's documents. I don't know what Julian's relationship was with the hackers or with Russia or with the Trump campaign, and those facts would be significant to me. So I have gone publicly, I've stated publicly before that, that I felt that in 2010, with that initial set of documents, that it's impossible to distinguish what he's doing from what legitimate, that is mainstream, established news organizations are doing.
Okay, where else? Another question? Okay, let me come right around there. Here we go. Okay.
As somebody working with a news organization as well as being in the legal field, how do you feel the news does well or doesn't do so well covering current legal affairs? Like, as of currently, we have legal affairs like with the Mueller report, which seem to go at a pace that the public just does not want to slow down to.
Yeah, I think it's a mixed bag. I think there's a lot of good reporting on legal affairs, but it's necessarily simplified. And I think that when lawyers read my book, they'll see that I engaged in the same sort of simplification. I think that if I had a criticism overarching of say, something like the Mueller investigation, it would be the same criticism I had of the Whitewater investigation, that the public is eager to know what's going on, the reporters are eager to find out, and many times the focus is on, you find a source who got a subpoena, you find a source within the investigation who has a particular point of view. We probably need to do a better job when we're covering investigations to put it into context, that people should not be surprised that an honest investigation like Bob Mueller ran could actually have turned out either way. That even though you're likely to hear from people saying, you know, they're looking at this, they're looking at that, that in the big picture, we should do better at educating people about how the system works. I certainly feel that in terms of grand jury indictments and all that kind of stuff. How does the grand jury fit into things?
Do you feel any concern about lawyers who have offered commentary on the Mueller investigation during the, as it's been going along? My wife swears she's never going to listen to commentary on cable television again.
Well, I would endorse that. You know, like in terms of life happiness, that's going to work out better. Yeah, it's, you know, in my role, and I said this the other day in the op-ed piece I wrote for the New York Times, that newspaper lawyers aren't the fairness police. You know, we're fact cops if we're anything. You know, we're not there to, we're there to defend the paper, and the fact is that when the founding fathers wrote the First Amendment, they were dealing with a very partisan press that was often unfair, and the First Amendment was designed to protect that. But as a lawyer and as a legal consumer and as a citizen, I do feel that the cable news epidemic, if you want to think of it that way, but it's certainly a proliferation, really puts a premium on everybody having an opinion all the time. You can't go on there and just sort of say, it's too soon to say, or, you know, I need to know more facts. It's just not compelling TV. The other morning, those of you who had the misfortune of seeing me on the Morning Joe show, you know, I was asked the question, would you compare Trump to Hitler? And I did the unthinkable. I said, no, I wouldn't. I'm not going there. I'm not going to do that. I mean, I don't think that's a particularly productive way for me to be commenting, but, you know, that's what they're looking for, someone who's going to take the bait and go with that.
Yeah, Jeffrey Toobin on CNN said a few 2 years ago, I saw him speaking, and he said the only thing he's not allowed to say on CNN is, I don't know.
Right, yeah.
Other questions? Where are we here? Okay, right here.
I had a question. What is the legal justification for the president's attack on the freedom of press? And do you think that, you know, if there's ever going to be a shift back to, you know, complete media fairness?
Yeah, so a couple of good questions there. As I talk about in my book, one of the things that's baffling about President Trump is that he, when he talks about what the law of libel should be, he's actually usually describing what the law of libel is. Now, he does it in more colorful terms, but when, he says that if you intentionally hurt somebody with lies, rich people should get a lot of money. That is our system, okay? If you intentionally lie about the facts, you win. That's the actual malice standard. You've overcome it. And so it's always a little baffling to me. And in fact, 10 days ago, the appellate division just ruled in a Trump libel case, only Mr. Trump is the defendant. He has been sued for libel by a contestant who was on The Apprentice, and the appellate division said that her case should go forward. That means that he is going to be making exactly the same defenses I make. He should be lining up on the other side of the ball. And he actually has said that, as I quote him in the book. He says that, when he came to the New York Times, they said, "Are you going to change the libel law?" And he said, "Well, I would like to, but then somebody pointed out that I need them. If I do that, I'm going to get sued more, so everything's going to be okay." It isn't okay. So it's not really, so to directly answer your question, I think the attack is never really about the law. It's really about the hearts and minds, about changing people's views, to sort of dismiss the press and see them as biased and in the way. And so the legal basis is not so much a legal basis, but philosophical and cultural, if you will. And do I think that things will go back to normal? As I said, my book is a testament to misplaced optimism, so I'm going to tell you they're going to be okay, and you can assume that they're not, because every time I say that, it doesn't work out. I do think, though, that this is a particular moment. I think over time that the pendulum will shift again. It has, and it usually does, yeah.
We can probably take a couple more questions before we call it a day. Over here. I'll be right there. If you're ever a moderator, they tell you never let go of the microphone.
Oh.
So here I am. You can stand. Thank you.
So, given the current state of social media that you alluded to earlier, what do you view as being the media's responsibility to kind of navigate the tricky waters that have come about, where you have to have breaking news on social media, you have to allow that platform, but giving people the option to then comment on those news stories or take them and run with them and kind of misconstrue facts has really led to a negative public discourse. So how do you perceive media's responsibility within that context?
Yeah, and it's a really good question, because my life would be a lot happier if we weren't tweeting out stories, because the way tweets work are meant to be provocative. They're not meant to be summaries and balance and so forth. So one of the things that I'm constantly pushing back against is that we'll have a really provocative quote that will say, Jones, ripped off the community. And then the next paragraph in the story will be, Jones explained that actually this was for the benefit of the community and this is how the community benefits. You're not going to get that chunk. What you're going to get is, Jones ripped off the community, and then link to the story. So I think we have to be careful that the tweets are fair, that they actually reflect the story. If they're provocative, they're not provocative in a way that either misleads or libels. But the truth of the matter is, so many people are getting their news that way. There's no way around it. We can't stop. I mean, it's one of those things that's a driving force. There's a chapter in the book called Us Versus Us, which is about how about standing up to your audience, and that I think sometimes that's the real act of journalism. Courage is not standing up to government, but standing up to the people who want to hear everything negative about the president. Sometimes we have to tell other stories. We have to play it down the middle as much as we can. So the tweets, though, elevate that, because they are designed to play to your audience's biases and impulses. And they're here to stay, and I just think there has to be better editing to make sure that they also capture what needs to be captured.
It's great to hear there's still a role for editors.
Oh,
right
man.
over here. Haven't been replaced by an algorithm just yet. There we go.
So I'm taking you back to when you taught journalism, and I was your student, and you indoctrinated us 3 sources, 3 sources, 3 sources. Now I'm on the other side where I get interviewed often, and it seems as if in community journalism, that whole idea of 3 sources is gone. You're at a newspaper where obviously they do like 18 million sources. What are your thoughts on the journalists who are coming up the pike and the idea of doing your research? So I'll be interviewed, and then someone will go to a Facebook page for the rest of the sources, and I have to call up the newspaper and say, this is incorrect. They only interviewed me.
Yeah. And I wouldn't say 3 sources is a rule, but it's a good guide of thumb. There's some cases where you don't need that, and there's cases where you need a whole lot more than that. But yeah, you put your finger on something that's really a problem, which is that many local newspapers feel really stressed financially because they are. You know, the crisis in local journalism is real, and it means that people are being paid less. The talent reflects that, and we live in this incredible information environment where they can go other places and think they're getting facts and so forth. And there's no easy solution to that. I think I've said that before, but there's no easy solution. I think that in part of it is that you're speaking up when you're subject of a story, that you're pushing back, that you know, people are making demands on on the news organizations in particular, and that we're doing what we can to elevate it. But I think until the financial crisis is resolved, and I don't see a way to do that until we get better local journalism, unfortunately, we're going to get second-rate local journalism, and it's a real problem. I mean, that you see really top, and I don't mean to paint it with too broad a brush. I see people doing really great journalism in really small shops, but in many places we now have what the Columbia Journalism Review refers to as news deserts, cities, towns that don't have any coverage at all. And I think that's a really sad place to be.
Mm-hmm. Well, and one more right up here. Good. Well, now I'm not going to be able to get the microphone to you, so there you go. Thanks, Ken.
David, this is terrific. Just a quick question. There are some who suggest that the ultimate irony is that New York Times versus Sullivan, the Supreme Court decision, I guess it's the law of unintended consequences, laid the framework which untethered the media from truth, or not sometimes.
Yeah.
So, what is your opinion? What if there was no New York Times versus Sullivan, the libel standards remained rigorous, would a cable TV exist?
Wow. Okay. So, you know, you hold out that tempting side of nirvana, and then I'm going to have to come out against it. No cable news? Oh, yes. So, you know, Times versus Sullivan sets the standard that a public official, later public figure, has to prove there was a reckless disregard of truth to win a libel case, right? So what that means is that journalists can get a story wrong, it can libel a person, can hurt that person's reputation, can damage, and the publisher's still going to win because the publisher didn't act with reckless disregard of the truth. Usually that means that the publisher knew the story was false or entertained serious doubts. That's the standard. So it makes it very difficult for public officials and public figures to win libel suits, and that has worked. It's driven down the number of libel suits. It is kind of this fundamental principle in U.S. law that we have the right to be wrong. I once had an Arabic speaker try to translate that for me, but it didn't work out, the right to be wrong, and I could tell everybody was confused. But anyway, here's where I come out on that, which is that nobody in my job vets stories to that standard, right? Nobody in my job says, so the reporter turns in a story, I don't say to the reporter, do you entertain substantial doubts? No, I don't. Good to go, okay? Good to go, you know. Do you have actual malice? No, I've never, no, not me. You know, I have the artificial malice, but not the actual malice, right? You know, our standard is truth. And so what it does is it cuts down on the litigation, but doesn't change what we do. And you're probably right that there are organizations that are less pure about that, you know, if they're not going to get sued, they're going to publish it. A reporter who used to work at one of our papers then went to work for one of the new outlets, and she finished her story. She goes to turn it in, and she asks, where are the editors? And the person running the place, I'm not going to use the word editor, the person running the place says, the public is our editor.
Oh, great.
We put it out there, and if it's wrong, they'll tell us about it. Okay. That's not a great system. So I still believe in that Times versus Sullivan is valuable, but it has to be met with also a commitment to the truth, to getting it right.
So give us a prescription for how we can take care of one thing that a very big thing, not just one thing that you point to here. You say that there's a fight taking place in the country for the hearts and minds of the public, a nationwide reckoning about what the press was going to be in American society. And you say the law can only do so much. It can give the press the freedom to matter, but it can't make the press matter. It doesn't really matter how much freedom of the press has in the society if the press is not believed. A distrusted press is a little different from a shackled press. It lacks the authority to mobilize public opinion against wrongdoing, corruption, and misguided policy. So given the fact that there is a significant effort to diminish the authority of the news media, how can we make the First Amendment matter to people? How can we overcome, do you think, this, how do we win the war?
I think we go out and talk about the issue, and I think it's for those of you in the room who are not hardened progressives and who are not hardened conservatives, if you're in the middle group, it's a good time to talk about the First Amendment. It's a good time to talk about the value of free speech and a free press. You know, it may take that we have some Watergate-like scandal. That was the last time there was that renewal where people say, whoa, you know, I'm glad the Washington Post was here to break that story. I was glad they're here to tell that story. And it may take that. I mean, one of the things I try to convey in the book is that, you know, people see New York Times reporters, so they think, you know, Manhattan liberal, which I'm not, okay? Neither. And that, you know, I grew up in a very conservative place in Illinois. My mother was a World War II veteran. My father was a World War II veteran. They were patriotic people. But when you're growing up in Illinois in the 1960s, there's one thing you know about politics, and that is the governor goes to jail.
That was so true.
Otto Kerner went to jail. Yeah. Dan Walker went to jail. Now, in fairness, the third guy indicted but got off. Okay, so, okay, all right. The Secretary of State died. They found shoeboxes full of money. Paul Powell died. Shoeboxes full of money in his office. And when you grow up like that, whether you're a liberal or conservative, you really want a free press there to help that not happen if you can do it. We learn to distrust the government, and that's not a bad place to be.
David McCraw, Truth in Our Times.
Thank you. Thank you.
Great.
Thank you. Thank you. I just want to say one thing, because I'm sitting here and I'm looking at you, and so you don't see this and you're not living my life, but it's really touching because there are people here who I went to school with. There are parents of New York Times reporters. There's students I had at Marist College, and there's my fellow board members, trustees, professors from this school. And if any of you are students here, this is why you should be at Albany. Thank you.
I want to thank you both for being here. It was really a wonderful afternoon, right? And we learned so much.
Thank you.